Is this on the first felony? It's mandatory, right? Not mandatory.
If you want to go to trial and not accept a plea agreement, then listen to your attorney and do what he's telling you to do.
Okay, so basically it's completely off the table right now, the plea?
Yeah.
Right there, and there.
What is all
The information, man. They've been gaslighting me for 5 weeks straight. Been doing my best to get to the population going on and try to stay out of trouble. They all up on the microphone.
All right, this is, stop talking. This is clause numbers 24 DCCR.
Right away, the judge is setting the tone. Nothing here is automatic. A plea deal isn't mandatory, but ignoring your lawyer's advice in a serious felony case is usually a dangerous gamble. The real question is, does the defendant actually understand what he's risking?
500, 24 DCCR 1614, 1615, 25 DCCR 0436, and you're Traylon Hill. And Mr. Hill's charged, go through this, in cause number, the first one, 1500, with obstruction or retaliation. Do not do that again. Who's in here for him?
My grandmother.
All right. Ma'am, can you move over to that back corner so that he cannot see you and be distracted? Thank you for being here. Mr. Hill, you just don't know how to behave, do you? Saying you're sorry doesn't matter.
Notice how quickly the judge interrupts. Courtrooms run on structure and respect for procedure. And when a defendant starts arguing narratives instead of answering questions, judges often tighten control immediately. That's usually a sign things are about to escalate.
This is nonsense. Since we were here last time, I don't even know how many more pages of the nonsense that you've been doing in our jail.
It's gaslighting. It's solicitation.
Okay.
This is subtle but powerful. The judge moves the family member so emotional support doesn't interfere with courtroom discipline. Judges want decisions based on law, not reactions, signals, or emotional reinforcement from the gallery.
And I've been trying my best to stay out the way. I'm getting bullied over the microphone. I have inmates there encouraging the inmates to harass me, call me punk, alpha, profit, plenty of things. Gangster play, mad.
Yeah.
Water. Man, I'm just trying my best to stay out the way.
Okay.
I got a job, I got a home, an actual home. I don't stay in apartments or anything like that. My mama actually owns rent houses. And you know what I'm saying? I'm actually trying to take care of the family business. My dad's 76 years old.
Yeah.
My business stay out the way.
Well, it doesn't look like you are.
Yeah, it's tough in that facility. It's a war zone.
So one of the time you're running back and forth, playing like a little kid in the day room.
I work out.
Who made you do that?
I'm a boxer. I work out.
Are you allowed to do that in the jail?
In the rec room, yes. Ma'am.
Okay, so are you allowed to do it in the other room?
I have a one-man cell in the facility.
Are you allowed to do that?
Yes, ma'am.
You are?
I'm not running freely throughout the facility. But I do work out a lot every day.
So who made you dash the floor with water?
Everyone in that facility has a water
Who
bottle.
made you dash the floor with water?
I'm not the only one. No, that was
Listen
me.
to my question.
No one did.
No, but you did it on your own,
Yeah,
right?
it was
Nobody's
okay.
stop talking when I'm talking.
This is where defendants often make a critical mistake, thinking jail behavior doesn't matter. But disciplinary reports can influence bail decisions, plea negotiations, and even how a jury views credibility. In legal terms, reputation inside custody can follow you straight into trial.
I'm going to ask you some yes or no questions.
Okay.
So nobody's making you do those things, right? Nobody bullied you into dashing water, right? Yes or no?
Yes, ma'am.
Okay, hold on a second. What about why do you continue to make comments to the female officers out there? Why do you think that's okay after you've been told not to do that?
Sitting in the cell all day long, man. When I see them women, I get hurt. I'm a little boy. I admit that.
'Cause you're a lover boy.
Yes, ma'am.
So you understand that part of all of this trouble and you not being able to get your cases worked out is because you can't.
Switching to yes or no questioning is a classic judicial move. It limits storytelling and forces accountability. When a judge does this, it usually means they believe the defendant is avoiding responsibility and patience is officially running out.
Follow that rule.
Yeah, I hate that.
Did somebody bully you into being that way to those officers?
In a manner, you know what I'm saying? When
Oh, yeah?
I'm dealing with these stressful inmates, you know what I'm saying? I love to be around my
Okay.
mama boy.
Judge, based on his Sunday night activity, I'm pretty sure there'll be a new case coming.
Yeah.
I've got to call into the investigator for the sheriff's department to find out
Okay.
when they'll bring that over. But I would ask them to go ahead and send these in for trial.
And we've already talked before about the fact that everything that's happening, a jury is going to know about all that. You understand that? Okay. And do you think that's going to help you or hurt you when a jury hears how you're behaving in the jail?
When it comes down to video footage and how I explain it, I think my efforts will be pretty good.
You think so?
Yes, ma'am.
You think
And here's the turning point. Confidence in explaining things later doesn't erase legal exposure now. The judge is warning him plainly. A jury won't just hear the charges. They'll hear the behavior too. Rejecting a plea at this moment could mean trading certainty for massive risk.